Hi, John Farrell with the Farrell Law Firm. Today we're going to talk about the 5 things you need to do to make a valid will in just a few minutes. But first, make sure you subscribe to the channel. We put out new videos every Tuesday and Friday. And make sure that you hit the like button because every like helps. Hi, John Farrell with the Farrell Law Firm. Today we're going to be talking about the 5 things you need in order to make a valid will, and it just takes a few minutes. So why don't we just go ahead and jump right into it. All right, so number 1. The first thing is that your will has to be in writing. And so we're actually talking about Georgia law here. There are 50 states in the union and every state regulates its own wills. So make sure that you check out with your local state about the requirements for a valid will. But here in Georgia, every will must be written. And really what they're talking about is that oral wills are not allowed here in Georgia. So in other words, you can't tell someone what your last will and testament would be. It just wouldn't be valid. It has to be in writing. Now, there's a lot of controversy over what type of writing it should be. People get confused here because they get confused with the term holographic will. There's a case out there in Georgia that says that holographic wills are not valid, and some people transpose that into thinking that handwritten wills are not valid, but that is not true. Handwritten wills are valid here in Georgia because it is a type of written will. The requirement is that the will just has to be written. Well, there's 2 types. There's handwritten and typewritten. That's where the word typewriter comes from. So oral wills are not allowed here in Georgia, but handwritten wills and typewritten wills are valid here in Georgia. In fact, those are the only ways that you can make a will here in Georgia. It has to either be in your own handwriting or in someone else's handwriting, but it has to be written and it can be typed, which is a type of written will. All right, so that's number 1. Number 2. All right, the second thing in order to have a valid will here in Georgia is that you have to be old enough to write a last will and testament. Interestingly enough, here in Georgia, the age is 14. That is the minimum age you have to be in order to make a valid will here in Georgia. So you can be 14 years old, write your own last will and testament. It is the youngest age in the union in order to be able to write a last will and testament, and it's 14 years old. So there's a little trick when it comes to 14. Oftentimes when people come in with wills that have been done by other people, I will look to make sure that it has that magic number of 14 in there. Lots of times people, especially if they don't do this for a living, they'll put 18 or they'll just forget to put it there altogether. But if I see that the number 14 is in there, then I know that someone that probably does this for a living drafted the will. So in order to have a valid will here in Georgia, the second thing you need is for you to be over 14 in order to draft your own last will and testament. Number 3. The number 3 thing you need in order to have a valid will here in Georgia is that you have to be of sound mind. Now, what does that mean? It really means that you have to have the mental capacity in order to really know what you're doing. Well, as I mentioned earlier on how you can be 14 years old and write your own last will and testament in Georgia, well, that means that the requirement to have the capacity in order to write your own last will and testament is actually very low. So it doesn't take much to be of sound mind here in Georgia. But in order to have a valid will, the third thing that you need is to be of sound mind. Number 4. The number 4 thing that you need in order to have a valid will here in Georgia is that the will has to be signed by the person making the will. We call this person the testator. They're the person who is writing their last will and testament, the testator. And so the testator must sign the will. You can draft a will either in your own handwriting or have it typed up, but if you do not sign it, it is not a valid will here in Georgia. So in order to have a valid will in Georgia, the number 4 thing that you need is to make sure that the person writing the will, the testator, actually signs the will. Number 5. All right, so the number 5 thing that you need in order to have a valid last will and testament here in Georgia is that you need people to witness you signing the will. So in Georgia, the requirement is that you have 2 witnesses. In some states, it's only 1. And in other states, you can have oral wills, you can have video wills. But here in Georgia, it has to be in writing, has to be signed by the testator, and it has to be witnessed by 2 competent witnesses. Really what that means for the most part is that they need to be over 14 years old, and they should probably not be one of the beneficiaries of the will. If you were to make one of the beneficiaries of the will one of the witnesses, well, then it would essentially disinherit them. So just get 2 competent people that you know to serve as witnesses. And so the number 5 thing that you need is that the will has to be witnessed by 2 people. So those are the 5 things that you need to have a valid will here in Georgia, and it just takes a few minutes. So the 5 things you need: has to be in writing. You have to be old enough in order to write your own last will and testament. You have to be of sound mind. It has to be signed by the testator, the person who is writing the will. And number 5, it has to be witnessed by 2 people. All right, so that's what it takes to make a valid will here in Georgia. Just takes a few minutes to get all those things together. And so if there's anything that we can do for you, please don't hesitate to reach out to us. If you've watched any of our videos for any amount of time, you know that what we do is we help people get their estate plan into place. And so one of the things that we've done is that we have written a book called Estate Planning for the Modern Family. And you're going to want to grab a copy of that book. So I'll put a link in the description below so that you can grab it. If you want to learn a little bit more about the firm, perhaps schedule a free consultation for yourself, just give us a call at 678-809-4922. That's 678-809-4922. Or there's a link in the description below where you can sign up for a free consultation. All right, so that's all we have to talk about today. Make sure that you subscribe to the channel. We put out new videos every Tuesday and Friday. And make sure that you hit the like button because, hey, every like helps.